Timeliness is a very important part of community court. The attorney was mentioning the number of appearances that often take place in the traditional court system. We want to change that. We have offenders appearing, if they're arrested by the police today, they'll appear in community court tomorrow. If they're arrested by the police today and released either by the police on an appearance notice or by a justice of the peace overnight, they'll appear within, the appearances are coming up within 2 days, 2 or 3 days, much more quickly than we've ever seen before. And that's required the police to change their practices in some ways, obviously, because they have to do the reports, get them in more quickly. It requires the Crown Counsel to be able to deal with the volume of cases in a much more timely manner. It requires the whole court system had to change to do that. We don't do bail hearings in community court, contested bail hearings. If the issue is the terms of release, we do that. But if the Crown is seeking someone's detention and the person seeking their release, that takes place over in the traditional court. We're not interested in getting involved in that adversarial approach. We don't do trials. If somebody pleads guilty in community court, we deal with them. If they plead not guilty, their trial is set at Main Street. But the difference is we do that in 1 or 2 appearances, not 8 or 9. People who come to community court, and I can tell you that most people who have been arrested and come to court since we opened we've had 18 business days now, most of the people have come to community court and wanted to deal with their case in community court. We have set very few trials. The first thing that happens when they come to community court is they're asked by the community court lawyer if they're prepared to consent to an assessment as to their needs. If they do, then they're assessed by the triage team. The Crown's position is very much influenced by the assessment of the triage team, and we actually do the assessments on day 1 before they actually even come into court. So we're able to resolve a lot of cases right at that point. The triage team is made up of 2 probation officers, a forensic liaison nurse, and a forensic psychiatrist, and a Vancouver coastal health nurse. And they have support, in other words, working also in the court building in the same office area, a financial assistance worker, a Vancouver Police Department sergeant, a native court worker, a BC Housing support worker, and a victim services worker. So all of those people have access to a lot of information in terms of their databases. We can find out whether somebody is supposed to be seeing a particular community care team. This person is actually being placed in BC Housing somewhere. They can determine all of that very quickly. Oops. So first I must warn you that anything can be taken down and used to assist you. That's kind of our claimer. Once the triage team has done its report, they make a recommendation for a plan. As I say, it's usually then adopted by the Crown. The range of sentences in community court is the same as in any criminal court, realistically, because we're operating under the same legislation. Alternative measures, which is available under the criminal code and used by the Crown throughout the province, is being done differently in community court. Alternative measures in most places comes about when the accused person asks if their case can be diverted, not go through the court system, but to admit responsibility, do some community service, something like that, with the benefit of not having a criminal conviction. But it's a passive system. In other words, the institution, the court and the Crown, they don't do anything. It's really up to the accused to know about it and step forward. In community court, when the Crown does charge approval, they identify cases that they think would be likely suitable for alternate measures. And they have changed their criteria so that, not changed, but they're using a more liberal interpretation of who's appropriate. So somebody who was in trouble and had a conviction 2 years ago, but has been not convicted for 2 years and is arrested for shoplifting, they might qualify in community court for alternate measures. The alternate measures, a lot of people have gone into alternate measures, whereas in the traditional system, if you go into alternate measures, your case might be adjourned for several months so something can happen. We adjourn it for 4 or 5 days. People start their community service that day. They write their apologies that day. They do whatever they're going to do within days of coming to court. Then they come back to court, and if they've done what they're supposed to have done, the Crown withdraws the charge. So far, it's been remarkably successful. I'm surprised at what some of the people have done. You wouldn't have thought that they actually would have followed through, but because of the new approach, I think, and because of the timeliness, like you don't have a month to think about it. You're going to start this afternoon. As a matter of fact, we actually do start this afternoon. We give them a lunch so they don't have to leave the building. And we have one of the local restaurants that donates the lunches every day. So that's another example of the community getting involved in the community court. This fellow who owns a number of restaurants heard about community court, called up one day and spoke to the coordinator and said, what are you doing for lunch for people who are in your program? And they said, well, we're going to have to buy them lunch, I guess. He said, well, no, don't do that. We'll provide the lunch. We're not asking for any publicity, but that's our contribution. We also have a program at community court which is modeled on the mental health courts, of which there's one in Toronto, and there's many across the states. The one that we went to see, and I think you did, the one in Brooklyn. Did you go to that one? Yeah. Yeah, the one in Brooklyn. I was very, very impressed with what I saw there. And this is the version of mentally disordered offenders. These are folks who often come to court. There's an issue of whether they're fit to stand trial. They're sent off for an assessment in custody, often end up in hospital. They're found not fit. They then get fit. They're then released from custody. They stop taking their medication. They become unfit again. And we sometimes spend a year or so, sometimes with relatively minor offenses, sometimes with serious offenses. But the whole effort is put on getting them fit to stand trial as opposed to dealing with their mental disorder. So what we will do with those folks in community court is we will keep them on bail up to a year. In Toronto, they had somebody on bail for a couple of years, keeping them in the mental health system. And at the end of the day, they never entered a plea. The Crown withdrew the charge because the Crown was satisfied that the public interest had been served by keeping them engaged on their rehabilitation and their treatment and not focusing on fitness to stand trial. We have a number of brief interventions in community court. We have a community service I've already mentioned. We have information sessions every day that are put on by Coastal Health on addiction services. Vancouver School Board runs a GED introductory program. We have a shoplifting program that's run by Elizabeth Fry. We have a whole variety of programs that we can sentence people to that are done that day or the next few days right at the courthouse. And we have activity rooms to do that. We also have the assertive case management approach, which I'll deal with in just a moment, and then, of course, incarceration, but with case management after.